Great. So I think we're going to go ahead and get started. Thank you for joining us today for our Spotlight on Colorado's Cannabis Market webinar. For those of you who don't know me, I'm Jessica Scardina. I'm a partner here at Vicente, Sederberg, and chair of the Colorado Regulatory Department. With me today, Charlie Alovisetti, another partner at VS. He's chair of our corporate department. James Nechleba, he's counsel at Vicente, Sederberg, and another Colorado regulatory attorney. We have Christopher Stefan joining us today. He's a principal with Cannabis Capital Advisors. And Catie Wightman, she is an attorney with Vicente Sederberg and a Colorado Hemp associate. So today we're going to go over some of the recent changes to Colorado state and local regulations and some business opportunities arising out of those. These include delivery permits, hospitality licenses, social equity and accelerator licenses, as well as changes to the market following PubCo and a Colorado hemp update. So I'm going to turn it over to Charlie to talk about some PubCo market changes.
Thanks, Jessica. So, the big news, from a, business perspective in Colorado is public companies can now buy licenses in Colorado. Previous to the change in law, you saw some public companies sort of do arrangements with licensed companies to try and, transact. There were some major MSOs that had sort of deals in Colorado that were flat fee licensing deals or otherwise, but they were prohibited from directly holding a license because the rules limited you to, 15 natural persons on the license. So that has all gone away. There are new ownership rules in Colorado. We don't have time here to go deep in the details, but the bottom line that you need to know is public companies can own licenses in Colorado. Private equity firms and venture capital firms can also own licenses in Colorado. And Colorado is actually unique in the respect that there are specific rules dealing with background checks for private equity and venture capital funds. So with public companies, it's possible to own a license in Colorado. The background check will focus on your 10% plus shareholders, and then your officers and directors, basically the C-suite and the people on your board. It's the number of people who've gone through the process. The initial deals, like you look at this Columbia Care one, when they bought TGS, the green solution, that one took a long time. Sometimes these delays are due to the number of local licenses, but I think the regulators are getting more comfortable with public companies. Now, there's always nuances here. So, if there's something funky in the structure, you should think about it ahead of time. But here are a couple big deals we just kind of broke out for you. And by the way, so we don't have everything, it's not the complete universe of deals here. PharmaCann bought LiveWell. That deal hasn't closed yet, but that's going to be a major change to the market in Colorado. Schwazi is another public company in Colorado that owns a number of licenses. And so here we've got Medicine Man, the Columbia Care deal. So I don't need to kind of go through the notes, but I think the important thing to realize is that sometimes the metrics for these public company deals are going to be different than the multiples you see in private deals, particularly because the consideration's in stock. On the private deals, the consideration is almost all cash. It's usually a mix of cash and seller financing. And that, those multiples are typically lower. I think that the multiple on the Columbia Care acquisition of the green solution, which isn't here for the last 12 months, was like 2x revenue, which would be, higher than what you'd see in a private transaction. But of course, the consideration was all stock, so it's a little bit different. So that's Columbia Care, and this is Cura Leaf. Cura Leaf, obviously a very major player in the cannabis world that has acquired Los Sueños Farms, a major growing outfit down in Pueblo. So they now, if you look, they've got over they're in 23 states with over 5,000 team members. So it's a pretty significant operation. So that's, I'm going to turn it over to Christopher now, but the bottom line is public companies are now in the market in Colorado. Obviously it's impacting the M&A market significantly because, they've been kept out of Colorado for so long due to the restrictive regulations, but that's all in the past now. And I think we'll continue to see consolidation and entrance of non-cannabis, of non-Colorado MSOs into the Colorado market.
Great. Thanks, Charlie. This is Christopher Stefan from Cannabis Capital Advisors of Desarrollo Real Estate. And my firm does a lot of work in the M&A space, trading cannabis businesses, licenses in real estate, and primarily in Colorado. Probably seen about 25 transactions at our firm in the last year, and that's been a significant amount of volume. And we have been working with many public companies to enter space in Colorado. The real reluctance of sellers to take stock has probably limited and tempered the amount of transactions that public companies have done in Colorado. You see this Columbia Care Medicine Man looks like it was, a 25-30% cash, and the rest was $33 million in stock, which is pretty significant amount of stock. You also saw similarly with General Cannabis and Trees have merged. General Cannabis is a longstanding public company that's been operating in Colorado in kind of a consultancy model, but now is moving to a plant touching bricks and mortar and multi-state presence with their merger with Trees. That's not approved yet, but if approved, that will have they will go under the flag of Trees. That was another $39.5 million deal. It looked like about a 2 times revenue of gross revenue net of taxes, so net sales multiplier. And that was a heavily stocked deal as well. Almost primarily, I wouldn't say 100 or 90%, but a heavily stocked deal in Colorado. And that's a little different, with Medicine Man selling to Columbia Care. I think that's an exit for a lot of the companies and the operators with Los Angeles and Cura Leaf, for those operators to move on and these big companies to move in and operate. But with the Trees General Cannabis deal, it's a different kind of deal. It's a merger where they want the businesses to stay on and operate. And so you're kind of seeing 2 different kinds of public company interest here. Is it an outright sale for the sellers so they can exit the business and stay on in some capacity, or is it something where they're buying the company to stay on, and how does that affect valuation going forward? So just a couple of interesting transactions. Also, Schwaz purchased a grow recently. About a $6.7 million transaction. So you're seeing more. They purchased an outdoor farm this year. Cura Leaf purchased an outdoor farm. Prior to that, they purchased a manufacturing facility and Blue Kudu brand as well. So you're seeing the interest from the public companies come to Colorado, and I expect you'll see some more of that in the coming months.
Great. Thanks for that, Charlie and Christopher. So moving on to some of the bigger state and local regulatory changes over the past couple of years, I'm going to jump right into delivery. So the medical delivery program started January 2nd, 2020, and adult use delivery went live January 2nd, 2021. I think it is important to note that delivery permits are not standalone licenses. You have to attach the permit to an underlying business license. So only stores and transporters are able to obtain delivery permits. And both of those would need state and local delivery permits if required by the local jurisdiction in order to deliver cannabis in Colorado. The program has been pretty limited thus far, just due to the requirement that the local jurisdiction where the applicant is located has to have both permitted delivery and be accepting applications. And unfortunately, that's just not the case in many jurisdictions yet in Colorado. A couple of technical operational requirements for delivery permittees. So transporters can obtain delivery permits, but they're not actually able to take orders. The order has to be taken by a store, which can then utilize a transporter to facilitate the delivery. Stores can also deliver on their own if they have state and local delivery permits for that facility, and they can package and prepare deliveries either at their store or their off-premises storage facilities. Anyone who's conducting deliveries needs to be RBT certified before their first delivery takes place. A couple of interesting vehicle requirements here. I'm not going to go into all of these because I don't want to get too far into the weeds, but the vehicle has to be owned or leased by the licensee that holds the delivery permit. So that could presumably be the transporter or the store. Obviously, marijuana can't be visible from outside the vehicle. You can't transport more than 10K in retail value of marijuana or products. And just for safety's sake, all drivers and passengers need to be badged. As far as order requirements go, you can only deliver to private residences. So it needs to be someone's home or apartment. No schools, colleges, universities, or public or commercial property. You can't deliver between 12 and 8 a.m. So all your deliveries need to be completed by midnight. You can presumably take orders outside of those windows, but need to stay within that time window to complete your delivery. There are delivery limits for medical and for retail. And online and phone payments are permitted, which is a general exception to the prohibition against retail stores taking online and phone payments. And just something of note, if you use an online platform provider to take delivery orders, you need to disclose that provider to the MED every year at renewals. So just keep that in mind when you're negotiating your terms. So on to jurisdictions that permit delivery. As I noted, they're fairly limited. Along the Front Range, Thornton and Longmont also permit delivery, but those are restricted to existing licensees and only permitted within the limits of those cities. Aurora actually allows cross-jurisdictional delivery, which is notable. Their delivery program began January 2021. So existing Aurora stores can deliver, and then stores outside of Aurora can deliver as well if they have a state delivery permit, a permit from the jurisdiction where they're located, and an Aurora general business license. Their delivery program is somewhat limited to social equity applicants, although not completely. Like I said, existing stores can deliver, but new transporter licensees who are obtaining delivery permits must be social equity applicants. Denver is allowing delivery as well. They started taking permit applications July 1st, 2021. Until 2024, the delivery program is exclusively limited to social equity applicants. So existing stores, existing transporters, those cannot deliver unless they are partnered with a social equity transporter. The delivery permit will be noted as an endorsement on the business license. And I think Denver maintains a database of the delivery permits that have been issued thus far. So moving on to hospitality, obviously COVID has been a big limiting factor for hospitality establishments. It's difficult to open any business in this environment, much less a consumption lounge. So I'm hoping we'll see some more activity here in the coming year. There are currently only 2 licensed hospitality establishments in Colorado. One is in Colorado Springs and the other is in Denver. Both of these were essentially grandfathered in under existing programs. And I'll turn it over to Christopher again for a minute for some of his thoughts on Denver's previous hospitality ordinance and where that market might be headed.
Yeah, and I don't want to jump too far ahead because it probably ties into some of our next points as well. But, Denver has had a social use ordinance in place for several years now. It has been somewhat hamstrung by the ability to locate and zone properties that would qualify to allow this use. And, the city knew that when they made the law. We even had a task force to look at the laws and to see what could be done to make sure the program has been successful. And that has really been an adjustment of the setbacks and the zoning requirements in order to cite a hospitality or a social use kind of license. And the city has the existence of only one cannabis club in kind of an industrial under trafficked area kind of shows you that they've really been able to preclude the proliferation of any social clubs. And I really suspect with hospitality that they're going to have the same troubles within the city of Denver. There might be places that qualify, but Boulder hasn't really allowed it. A lot of the municipalities haven't allowed social use or hospitality yet. So though we have a great law at the state level and now it jives and it is kind of synced with the Denver law and the policy, if we're not able to cite and locate a hospitality business, then I don't know that the program is really going to, really create new culture and new events and new businesses and new opportunities. We will still need those setbacks in order to let what this law allows happen.
Yeah, and that's definitely, as I'll get into a little bit later, that's definitely a challenge in the Denver program, especially. A lot of the setbacks are pretty restrictive, so there just aren't many places that people can go. So with respect to the state hospitality law, the state permits 3 types of hospitality businesses. There's the fixed premise consumption lounge type model, a mobile premise, which is more like a party or a tour bus, and hospitality and sales, which allows limited quantities of marijuana to be sold and consumption to take place on site. A few of these operational requirements, and again, I'll try to avoid getting too technical here, but the hours of operation have to be between 7 a.m. and 2 a.m. There can't be any consumption or sales outside of those hours. You can provide consumption equipment as long as you are sanitizing these, obviously. No marijuana can be given away to consumers. But there is a way for the business to sell or give away food, drinks, or other consumable non-marijuana products. A couple different circumstances would apply there. So the first is where the licensee is selling or giving away prepackaged instant food and drinks like coffee, tea, pastries, stuff like that. But an interesting twist in the state law is that they allow hospitality establishments to operate inside of retail food establishments, which means you could open a consumption lounge in a restaurant or coffee shop or other similar establishment. You could serve food and drinks on site, both in the restricted access area or the consumption area, depending on how your facility is laid out. All your employees should be badged just for safety's sake, so nobody's going anywhere that they shouldn't be. You still cannot manufacture marijuana products on site, so you can't be adding marijuana to food or drinks. You would need a MIP license to undertake that activity. Another constraint there is that you can't co-locate a liquor license with a cannabis license, so they can't be at the same license premises. You can't sell alcohol. There can't be any consumption of alcohol or nicotine. But you can have a liquor license and a cannabis license in close proximity. You just need to make sure that they meet the state's definition of what is completely separate. And so that's no shared space, no shared physical space or overlap of licensed premises. They need to have separate addresses, which can be separate units, and no doors, hallways, or passageways between which any consumers can pass. Any windows need to be covered too. So as long as they are completely separate, you can have your alcohol license next door. As far as some local jurisdictions where you might consider opening a hospitality business, Adams County had a lottery in August 2020. They issued 5 tickets, and those lucky ticket holders get to apply for hospitality licenses. They have to do so within a certain time window, and if they don't meet that time window, then presumably those tickets go up for grabs to the public. Keep an eye on Adams County's website. They keep it regularly updated, and that's a really good source of information as far as what license types are available there. For Aurora is not currently allowing hospitality. It went up for a couple different votes and ultimately failed in September. We think that it'll probably go back to a vote after the most recent elections, which were last week. So we'll just have to wait and see what happens there. Their draft ordinance allowed for all 3 hospitality license types. But the bring your own cannabis model was limited to existing store licensees. And the hospitality and sales licenses are subject to a 24 license cap, but those will most likely be for new applicants. Blackhawk and Central City actually allow for hospitality too. Blackhawk is limited to 1 hospitality license, and that can be a consumption lounge or a hospitality and sales license. Central City doesn't appear to have any caps, but because it is a fairly small town, I would imagine that locations there are at a premium. Denver allows for hospitality, but as I'll get into a little bit later with an overview of the omnibus, all new Denver licenses are restricted to social equity applicants through 2027. Denver also allows for all 3 hospitality license types, and we anticipate that the applications will be released soon. The last I heard, they were supposed to be out in November, but I haven't seen them yet, so hopefully those will become available in short order. So in addition to delivery permits and hospitality licenses, there are a number of jurisdictions that are currently or will soon hopefully be allowing new stores, cultivations, and MIPS in Colorado. One of these is Golden. They passed question 2A, I guess last week in the general election. This should allow for a limited number of retail marijuana stores. So not just conversion for existing medical stores. This would presumably allow for new retail marijuana store applicants. So that's exciting. Grand Junction, I know a lot of people have had their eye on. They passed some marijuana-related ballot measures in April 2021, and city staff has been working on the regulations since that time. It looks like there's going to be a cap of 10 store licenses there. And the selection process is most likely going to be either a weighted lottery or a merit-based application. Things have been a little bit slower than they initially anticipated. So their first timeline showed an application release in the first or second quarter of 2022, but it looks like that's going to be delayed. And you can feel free to check back with us for updates there if you have any questions. Broomfield issued merit-based applications. Those were submitted August 2021, but their application review process is on pause in response to a lawsuit by some of the applicants, where it's looking like they're going to get back up and running sometime in December or January. And Denver is accepting applications for new stores, grows, and MIPS, and those are all restricted to social equity applicants through 2027. So, like Christopher mentioned earlier, locations in Denver are quite difficult to find. And I'm wondering, Christopher, if you have any insight there as far as where people can go, how they can find available properties, what their options might be for licensure in Denver.
Sure. So, yes, it's a very tall order. We often tell clients, they say, is it like finding a needle in a haystack? And it's like finding a specific needle in a stack of needles. And so, Denver has had a proliferation of stores over the last 10 years, and each of those stores has 1,000-foot radius around it. And every drug, treatment, school, and daycare also has 1,000-foot ring around it. So, the best option for would-be entrepreneurs would be to kind of build a GIS map, or kind of see where all these circles are and find the spaces in between the circles. And then once you're there, you kind of got to call every building and call every landlord. And then you got to say, hey, are you open to this use? Do you have a loan on your building? Can you allow a cannabis tenant? And if you do find a place that qualifies, that's going to be a real exciting, gold discovery. Really, you're striking oil. If you can find those spaces. I do believe they exist. They're very, very hard to find. Keep trying, keep asking, and really pounding the pavement is the best way to go. But if you take a step back and you look at the political context, and I kind of laid it out before, but Denver has had a moratorium in place for recreational cannabis dispensaries since they were legalized in about 2013, 2014. There was a time there where there was no moratorium on medical dispensaries. And so many stores went out and applied for a medical dispensary, which was later able to convert to recreational. But for, let's call it 6-7 years, the city of Denver said moratorium, no new locations in Denver. We don't need any more grows. We don't need any more stores. And so they weren't really going to take on a social equity policy that totally lifted the moratorium, as that's what this law says, is that, hey, we've lifted the moratorium and social equity people can apply for new stores, new cultivation, and new MIPS. But they didn't really want that to happen, because if they did, they would have removed some of these other setbacks and these other challenges. They knew that marijuana stores, licenses, MIPS, hospitality, everything was going to be precluded by the land use code and all those rings and circles I told you about, as well as the setbacks for these social use licenses. So they knew that they could throw a bone to the social equity community, so to speak, but really not undermine their policy of limiting the proliferation of cannabis licenses in the city of Denver. So just important context for everyone to understand, and to really, before you spend too much money on it or investing or buying trucks, just kind of understand where the potential pitfalls might be if they really don't want too many more licenses here in the city of Denver. One other, I think we've got a really close count in Wellington. Looks like it might pass in the city of Wellington. Looks like we might pass in the city of Westminster. Looks like it has failed in the city of Brighton as well. And those are just some other kind of metro area. Looks like it's passed in Lamar, which would be Meade. Maybe some new applications in the city of Fort Lupton as well. So those are just a couple of the places that were on the ballot this year that may open for new licensure.
Yeah, and if you guys have any questions about any of these new jurisdictions or where you might be able to locate a new business, feel free to reach out to us and we can help you out there. And like Christopher mentioned, with the Denver omnibus changes, the setbacks were a big part of the working group discussions there. Obviously, social equity was a huge piece too. So all new license types, like I mentioned earlier, restricted to social equity applicants through 2027, excuse me. And the omnibus also created neighborhoods of undue concentration, which adds another layer of difficulty to finding acceptable locations in the city. There are 6 prohibited neighborhoods for stores and 6 prohibited neighborhoods for cultivations. Those are areas that the city has determined are oversaturated with those license types. So you can't open new businesses there and you can't change location to any of those areas. Unless you're already in a neighborhood of undue concentration and you're moving within that same neighborhood, that would be allowed. The city also changed the setback measurement between stores and drug treatment facilities to be building to building instead of building to property lines. So that is helpful. But at least with respect to hospitality, they added a couple new setback considerations to outdoor pools and recreational centers. So it's tough to find properties, but like Christopher said, not impossible. And since social equity has been such a large part of this conversation, I'm going to turn it over to James to give us an overview of that program.
Hello, everybody. I hope everybody can hear me. Social equity and setbacks have caused a little bit of issue when it comes to if you want to establish a shop or something in Denver. A little bit of the background to that is that the program was established because, as it was pointed out, there is some concern that the residents who are most adversely affected by cannabis prohibition, the war on drugs, they should have some level of reparation for the damage that was caused to them. But the social equity designation by itself doesn't accomplish that on its own. Really, Denver and Aurora, certain places, they have limiting qualification for new licensure to social equity designees. And what I mean by that is that it doesn't necessarily create the outcome the localities are looking for by limiting new licensure to just them. Just because you are a social equity designee doesn't necessarily give you the business experience, the management experience that you need, or the capital that you need in order to run a business, let alone a marijuana business. And as our entrepreneurs here know, it takes a little bit of specialized knowledge of this industry to really flourish. So one of the things that we've done in the past to encourage this is we would have academic courses of study, but we don't really have those right now. So we have to rely on the old ways, and I like to call the old ways apprenticeships. And apprenticeships, as we know, typically train people for a trade. But the difference here is that if you look at the accelerator licenses and programs very plainly, you'll almost conclude that you're training your own competition. And the question is, why would you do that? And the answer to that, the only way to make that work is to understand that the Accelerator Program is not a charity program. Because if you look at it that way, it dies in the water. The basic rule of all businesses when they want to abide by government is, if I'm not being rewarded for doing something, and if I don't have to do it, and it harms me, I'm not going to do it. So practically, logically, structurally, the Accelerator Program actually mimics what can only be characterized as a franchise agreement. And the question, if you are a business that wants to establish itself in Denver, Aurora, wherever, or expand outward, is there any value in franchising? And I say, ask any fast food restaurant chain. All right, so let's move on to qualifications here then. Essentially, the first thing that you need to know is that this is really designated for social equity applicants. And to be a social equity applicant or designee, this is the designation that's provided during the suitability portions of licensure. You have to be a Colorado resident, no ifs, ands, or buts around that. You can't be the beneficial owner of another license subject to administrative action. And you have to demonstrate one of the following things. Typically, it revolves around where you lived between the years 1980 and 2010. It's usually a opportunity zone, some place that was very low income. The applicant, you or your family member, has to have been arrested for a marijuana-related offense. Now, the thing about that is that you don't actually have to be convicted of it. And it doesn't matter when you were charged of it or your family member. And it doesn't matter whether or not, it's something for paraphernalia. The designated wording is arrest for marijuana. So long as you have some sort of proof of that, you can get social equity designation. And additionally, there is income thresholds that can qualify you. For my money, the safest route is the knowing a family member or being a person who's been arrested for a marijuana offense, because I'm not sure how the localities will view things, but if you were designated as a social equity applicant based upon your income, the question becomes, what happens when you're a success? Do you lose your social equity designation? I don't know. And I don't know if the localities are grappling with that question yet, but business being what it is, you most likely want to aim for the most conservative route forward. Now, in order to maintain a social equity designation for a business overall, that business has to be owned 51% by social equity designated applicants. So you could have a combination of individuals that add up to 51% equity interest. That doesn't necessarily mean that they take 51% of the profit. It's just ownership interests. That's the one rule that has to be abided by in order to keep moving forward with this. Now, moving forward into the actual Accelerator Program itself, because the Accelerator Program is a partnership between social equity applicants and traditionally licensed businesses. You would need a social equity licensee who was never a controlling beneficial owner of a regulated marijuana business. Now, that's another thing that I'm curious about myself, in the fact that the accelerator licenses available are for MIPS, marijuana-infused products manufacturers, cultivators, and dispensaries. But they're not for transporters, and transporters are the only people in Denver who can get delivery permits for the purposes of delivery, and transporter licensees are limited to social equity applicants currently. So the question becomes, well, if you are already a licensed transporter and not a CBO of one of the accelerator licenses that is available, can you still be a social equity applicant designated to get an accelerator license? It's another question to ponder, but for what it is right now, the plain reading of the regulations or statutes is you can't be a controlling beneficial owner of a regulated marijuana business, full stop. Now, an accelerator endorsed licensee is a traditionally licensed cultivator, MIP, or dispensary that's operated for 2 years. They don't have any suspension or revocations in the preceding 2 years from applications. But if the traditionally licensed Colorado business doesn't have 2 years of operational requirements, they can show it by being a regulated marijuana business in operation in another state for the previous 2 years, or part of an incubator program, or they managed a regulated marijuana business for the 2 preceding years, or they were in a highly regulated industry for 2 years. So there's a number of ways to get around this 2-year requirement. But the benefits of an accelerator license, because you hook a accelerator, the social equity applicant, to the accelerator endorsed licensee, the traditionally licensed marijuana business, is that there's no state fees associated to applying for either an accelerator license or an endorsement for an accelerator license. Okay, there's no state fees associated with renewal of these licenses. There are fees related to the social equity designation. You know, it's a suitability application at the end of the day, but this is really what I like to say a 4-step process. You need to find a traditional business if you are somebody who wants to get an accelerator license. You have to find a traditional business to get endorsed as an accelerator endorsed licensee with the Marijuana Enforcement Division. Then you need to negotiate what's called an accelerator licensee agreement between the social equity applicant and the accelerator endorsed licensee. And then you need to customize that agreement into what is known as an equity partnership agreement. There's statements of equity assistance proposal and equity partnership agreement that get confusing when you start reading this thing by yourself. But to kind of sum things up, an equity assistance proposal is the thing that the marijuana or accelerator endorsed licensee provides to the MED to get their endorsement. The equity partnership agreement is what the social equity applicant provides to the MED to get their accelerator license. So you need to have the endorsement first, and then comes the accelerator license. And then after that point, you would naturally obtain the local licensure. Now, the first step, as I talked about, the equity assistant proposal. This is something that can be done before, as a traditionally licensed business. It can be done before you find a partner, a social equity applicant. It's essentially the bare bone details that you need that will govern the agreements between your accelerator endorsed business and the social equity applicants that will come to you. Okay, it's really just a boilerplate agreement, but when you change it, if you change it at all, the changes have to be reported to the MED within 30 days, which regardless, I would think that that would happen when you are negotiating out the equity, I'm sorry, I'm going to have to go back to say what this is, the equity partnership agreement. So in any event, when you change it out, I believe that when you have the equity partnership and agreement, that may constitute the changing of your equity assistance proposal. It's just something to keep in mind and keep in the back in your mind so we don't get too far into the weeds explaining this. But generally, the requirements of an equity assistance proposal is identifying the kind of relationship that you'll have, the most pertinent and relevant parts to the MED. It's the type of assistance that you're going to be giving, whether the services that you'll give to the accelerator licensee, your partner, will be subcontracted, the timelines of how your assistance will unfold, whether you'd be charging rent, like say you're giving land over or a building over and you're charging rent to your accelerator licensee. There are plans for stability that you have to provide, contingent agreements for when there's a change in controlling beneficial ownership to your accelerator endorsed license, because that will naturally affect the accelerator licensee's license. There's a requirement to disclose any violations within the past 2 years, regardless of whether or not you've been suspended or revoked, because as you'll remember, suspension and revocation is a precursor or pre-requirement to being an accelerator endorsed licensee. So the MBD just wants you to be transparent about your business itself. Now, there are also specific requirements for equity assistant proposals. Now, these are largely dependent upon whether or not you are going to have a shared premise or a separate premise with your accelerator or licensee. For my money and my examination of the rules and regulations, I would strongly point you in the direction of having a separate premise, because that is more in line with a franchise agreement. Now, when you apply for a endorsement, an accelerator endorsement on your license, you don't necessarily have to pick whether or not you're going to do a shared versus separate accelerator agreement. You can actually provide both. proposed bill. Like I said, it doesn't cost you anything to put this application in. If you're rejected, they don't charge you anything along those lines. But the difference of shared versus separate premises, it's mostly an issue of liability. There's a lot more standard operating procedures that need to be in place for shared premises to ensure that, you know, everybody can account for what everybody else is doing, and everything is monitored in the ways that it's supposed to be. Now, in terms of accelerator endorsement and moving from an assistance proposal to a partnership agreement, the partnership agreements are pretty much the same thing as the equity assistance proposals. I had slide after slide after slide showing the differences between the two and underlying it, but mostly it was just a bunch of block texts with, you know, 2 or 3 points underlined. I believe that gets far too much into the weeds for the purposes of a webinar or presentation, so I eliminated them. But essentially, what you need to know is that your equity assistance proposal and equity partnership agreement, they can look dramatically different, but the main thing is that everything is transparent to the MED. The equity partnership agreement has to represent the full relationship between the accelerator endorsed licensee and the accelerator licensee, unless there are additional agreements that can be permitted. So for example, one thing that you can do is you can have a non-disclosure agreement between the accelerator endorsed licensee and the accelerator licensee to discuss the terms of your agreements. However, the non-disclosure agreement has to be provided to the MED. So everything is roundabout discoverable by the public by petitioning the MED. Now, this is a little bit of the specifics that relate to what has to be placed within the equity partnership agreement. If you're giving technical compliance or capital assistance to the accelerator licensee as the accelerator endorsed licensee, the timeline in which the assistance is unfolding. Could it just be employees here or money there? If they're charging rent, the rent amounts, the deposits, the length of the lease, the terms of the lease, those sort of things. In the event that there's a change in ownership of the accelerator endorsed licensee, how will the accelerator licensee be protected? Who handles fees for these changes of controlling business owners? Because the accelerator licensee can change controlling beneficial owners. They can add on additional social equity applicants, and they can reduce down percentages and what have you. And then finally, there's conditions for dissolution of the equity partnership agreement. It may just be the case that, you know, you don't want to stay lodged into one another forever. Now, something to keep in mind as well is that an accelerator licensee can only have up to 9 licenses, 3 apiece of the dispensaries, the cultivators, and the marijuana infused products manufacturers. An accelerator endorsed licensee, however, they can sponsor as many individuals as they'd like. So there's a little bit more potential for accelerator endorsed licensees, provided they aim themselves in the proper way towards the proper outcomes. And that'll take us over to the hemp update.
Hi there, can everybody hear me? So Colorado has had several notable changes to the hemp program over the last year. The rules for hemp products were effective in April of 2021. There was delayed effective date for testing and labeling requirements of July 1st, but those requirements are now in effect. There is still a delay on pesticide testing requirements for hemp products, just due to difficulty in laboratories being able to source testing equipment for those tests. A modified pesticide testing list will be effective January 1st, and then the full pesticide testing list is going to be effective on April 1st. In addition, CDPHE has recently released a notice to stakeholders regarding Delta-8 THC, which has been a bit of a hot topic lately. And the notice clarifies that THC isomers, including Delta-8 and Delta-10, they're not permitted in food or dietary supplements. It is notable, though, that CDPHE does not have regulatory authority over smokable hemp products or vaporizer hemp products. So technically, this notice does not apply to those type of products, although it does signal the state's reluctance to allow those Delta-8 THC products in the open market. Colorado's hemp plan was approved by USDA in September, and the Department of Agriculture is now going through rulemaking to implement that plan. The rules are expected to be adopted before the 2014 Farm Bill is repealed in January, and then that new program will go into effect. And then finally, the CDA has opened a portal online where you can do all of your applications, and they're going to be adding more functionality to that in the future, at which time you'll be able to submit all of your reports and everything online through that new portal. They expect that to be up and running when the new program starts in January.
Great. Thanks so much for that, Catie and James. It looks like we have about 13 extra minutes if we want to take questions. I do see a couple questions in the chat. Let me scroll down here. Sorry, one second. And I responded to this one separately, but Zach Yeager, I'm sorry if I'm butchering your name, but is Denver accepting new applications for non-social equity or accelerator licenses now? So currently, Denver is only accepting non-social equity applications for testing facilities and R&D licenses. The ordinance language says the director can only accept applications for new medical MIPS, medical transporters, and retail marijuana business licenses from social equity applicants. And then there is an exception at the end of that for testing facilities and R&D. And it looks like there's another question here from Michael Diaz Rivera. Does a transportation license allow you to transport hemp? I'm assuming you're referring to a medical or retail marijuana transporter license. If you're not, let me know. But medical and retail marijuana transporters, their licensing privileges only include the ability to transport medical or retail marijuana or products. So my initial sense there is no. However, testing facilities can test industrial hemp. So there are certain license types that are permitted to handle industrial hemp in certain scenarios. Okay, thanks. It looks like he was referring to marijuana transporter licenses. Let me see if we've missed anything else here. And anyone else, feel free to jump in if they see other questions. Raju Bhatt, with the state grant funds, are there funds for auxiliary businesses that do not touch the plant? I do not know the answer to that question. James, Charlie, Christopher, do you guys have any insight there? I'm guessing that's a no. I can't hear you. I think you're on mute. There you go. All right.
Chris, you want to start up or should I?
No, you go for it. I think you probably know better.
Well, I mean, the grants themselves are supposed to be directed towards the social equity individuals. And there's I think it's the Cannabis Business Office, a Cannabis Business Association out of the Office of Economic Development in Colorado. They have grants that they're interested in giving out, but they haven't actually developed what the language of the grants would be. It's just, hey, are you interested in a grant? Let us know. And that's not really how grant proposals work. You generally define the terms of what would qualify you for the grant, but it seems like they're trying to elicit information from individuals. So you might as well reach out to, I believe it's called the Cannabis Business Office. But you might as well reach out to them and our marijuana business office and see if you can't provide something to them saying, I'm interested because I'm not touching the plant, but I'm an ancillary service to it.
Great, thank you. I don't see any other questions in the chat. Christopher?
Jesse, I think someone kind of mentioned in the chat that there have been 5, and I read this in an article as well, 5 license applications from social equity would-be license holders to try to apply for licenses in the city of Denver. And I didn't know if anyone had any more color or backdrop on that. I'd read that. I don't know if that was verifiable, if those have moved forward, or if there's any public postings or ways to search what development those 5 potential social equity licenses have made.
Yeah, so I don't have any personal insight into that. I do know that the MED maintains a database of licensees in Colorado. I'm not sure if they have social equity listed on there. Let me pull it up and see. I know they have hospitality. No, so it doesn't look like social equity is on their public database list, which actually isn't surprising. I don't know that they want people's personal information listed there. I don't know what license types those people have applied for. Denver has a pretty comprehensive marijuana regulation website as well. We can provide links to these if people are interested after the webinar. But there's all kinds of information in here about how to apply for new businesses, social equity considerations. They have a great marijuana facility location guide. That's a good resource if you're trying to figure out if your property is compliant. And the MED obviously does as well. So just let us know what resources might be helpful to you, and we'd be happy to provide those. Okay, there's a couple more questions here. Let's see. So this one might be one for James. Does an accelerator licensee have to do business under the same brand as their accelerator endorser?
I think that the question really is, if you're a cultivator, can you only provide endorsement to an accelerator to do cultivation? If you're a dispensary, traditionally licensed business, can you only do endorsement of a dispensary? There doesn't seem to be a direct statement or explicit statement from MED saying any of that, but you know, it's something that is worth asking them. We can search that out. But if we're going by the plain wording of the regulations and statutes, no, you just have to be one, and you can endorse the other. If you're asking whether or not you have to be licensed specifically in the locality that the accelerator licensee is licensed, then the answer to that is no. No, you don't.
Great, thank you. And I see another question from Suli Clay. Is there an easy way to find out which localities will accept new social equity licenses? So I don't believe that there's an index of who is accepting new social equity licenses. However, there is a list on the MED's website that says which jurisdictions are accepting applications. So that would be a great place to start. Take a look at that list and see if there's a location that appeals to you, if you can find a property there. And then you can feel free to reach out to us and we can help you figure out whether social equity regulations are in place there or might be. I know Denver is one, Aurora is one, and that's about as many as I know of along the Front Range, but I'd be happy to look into it further if you have additional questions. All right. Looks like I've covered all the questions that I see in the chat anyway. Like I said, if anybody has additional questions after the webinar, you can feel free to reach out to us. You can reach us at any of these emails on the slide. Oh, another question. You're very welcome. So those are some of the major changes to state and local regulations over the past couple of years. As you can see, there's a lot of opportunities for new business ideas in and around Colorado. We'd be happy to explore those opportunities with you. So just reach out to us via email. You can call the office, and we look forward to hearing from you. Thanks very much for joining us today.